this is one of my favorite people in our whole area down here. Probably one of the most generous people. Not that she's a big donor. She wants to be. No, with her time. Mary Rose Papandrea is the academic dean for UNC Law School. But she is brilliant. I mean, you just look at her, click on her resume or her bio. She's absolutely brilliant. But what is more brilliant is she knows how to express a very complicated subject. I've had her, she's been so generous with her time. She's come over and taught several classes here. She did a lunchtime activity for us in the fall. That's why I begged to come over here. And she is just an absolutely fabulous colleague to have. And one of the things that she is single-handedly building a synergy between our law schools. And we're going to work more on that with some of the other folks at UNC, and we're looking to do it with the other law schools in our immediate area. But also, we want to extend this to our Lens scholars, because we want to build this synergy between law students who are interested in this area writ large, because there are many aspects to it. And I think that one of the things that you'll see is this very interesting aspect of the law, and it influences national security. I'm not going to take up any more of the time because there's only one thing about Mary Rose. Mary Rose, will you come up here?
Yes. What about me?
Can people see her?
I'm a little short.
Can people see her? You know, in the camera.
You said all those nice things, Charlie.
Thank you very much, Mary Rose.
Well, thank you. It truly is my honor to be here. Charlie is pretty funny to say he had to beg. I mean, to get invited to speak to this conference is really a pleasure and really an honor. And I think it's great we could put aside our rivalries in sports to bring together the schools. And I do look forward to building this partnership more and more. So today, I'm going to be talking about whistleblowers and national security, but it's actually going to be broader than that. I will talk about whistleblowers, but I think we're going to talk more about leaks generally, and also the press a little bit, and the press involvement in publishing leaks. And two big issues in the news lately. Of course, we have a whistleblower that helped launch an impeachment, and we have the Julian Assange prosecution, which is underway. The government has indicted Julian Assange, and he's currently awaiting extradition, challenging extradition right now. So I hope we can talk about the Assange prosecution as well today. So to give away the bottom line of my presentation, there really are no easy answers in this area. There really aren't. And it's only becoming more difficult with technology and the changes that we're seeing in the way that the government operates. So that's the bottom line. I mean, I'm not going to have a magic solution here, but my goal today is to give you things to think about, and so that you appreciate why this is so difficult, because we need to think about these difficulties as we try to navigate a solution. So one of the things I thought we should start with is just a definitional issue of what it means to be a whistleblower. So whistleblower as a term is a much more limited term than leaker, which is really could be refers to all sorts of unauthorized disclosures. But whistleblowers typically cover these sorts of disclosure. Typically, you'll see whistleblower statutes that provide some protection. Focus on these limited categories: allegations of perceived waste, fraud, abuse, illegality. The National Intelligence Community whistleblower provision talks about substantial and specific threats to public health and safety. So this is a very specific type of term that doesn't include every sort of leak. So leaks are all sorts of unauthorized or unpermitted transmissions of information. Another thing with whistleblowers, typically to get any sort of protection, they have to be made to certain, usually up the chain within the organization. and not outside to, say, the media, whereas leaks are usually to the media. So that's another really big difference. Now, the amount of leaks that we have is extraordinary. And you might say, well, really? Well, yes. So everybody is leaking, it appears. And they're not just the lower level disgruntled employee that you may have imagined. And again, I'm using this word leak as a very broad thing. It could be someone who wants to float, someone in the White House, for example, who wants to float a trial balloon on a policy initiative that they are considering. And so they leak it out and to gauge the public reaction. So the public officials, in fact, higher ranking officials use leaks frequently as part of their governing strategy. Teddy Roosevelt was, as far as we know, one of the first presidents to really engage in this activity on a large-scale basis. People in his cabinet got the idea, oh, this is a good way of figuring out if people like what we're going to do, and they started leaking. And so hence the leaking occurred. And so that's why I love this cartoon, because they're just leaks all over the place. And the motivations, as I suggested, do vary. It could be you have a leaker who wants to show the world how important, has some sort of megalomania issues, right? So of course, there could be some of those kinds of problems, but it often can be someone who's trying to make an impact on a policy or a plan. It could be a trial balloon, or in the case of someone we might think of more as a whistleblower, someone who's trying to report some perceived abuse, illegality, waste, fraud, or abuse. So President Obama was actually started with Bush, but then Obama really started the crackdown on prosecuting leaks. And I don't want to overstate this crackdown, because given the sheer numbers of leaks that happen every single day, the numbers of prosecutions are really, really low. So it's a crackdown, but it's more in the way of sending a message. I don't think they have to prosecute every single leak, not that they could, but they can prosecute enough to start sending a message to discourage the leaks from happening in the first place. And under President Trump, we've seen a continuation of this high priority on prosecuting leakers. So Jeff Sessions and now William Barr both have made it very clear that going after leaks is a very high priority for their administrations. And so I want to talk a little bit more specifically about why these presidents seem, from different parts of the political spectrum, seem to agree that it's necessary to crack down on leaks, because this is, again, I want to overstate it, but we've had very few leak prosecutions in our history, and now we see them happening all the time. And so one thing, and there's a whole bunch of reasons, from the government's perspective, leakers are not a whole lot different from spies in the impact that their disclosures can have on national security. So with a spy, engage in unauthorized disclosure to an enemy, or it could be an ally, when someone leaks information to the media and it gets published to the whole world, then the whole world knows our secrets. And so that can be damaging to national security. So from the government's perspective, the harm can be very similar. The sheer amount of data that is out there these days is staggering. And so there is a insecurity with being able to control this information. And so cracking down on leakers is a way to get some control over this information. If you can deter people from leaking, you'll get better control over this information. The number of people with access to this information has multiplied. And one of the criticisms that came out of the 9/11 report was that the government had not shared information as much as it should have to avoid the attacks. And so you see more information sharing, but that expands the number of people who have this information and who therefore could potentially reveal this information. And so that's another maybe change that could explain the uptick in leak prosecutions. The technology, as I mentioned at my outset, certainly is playing a massive role here. If you think about the technology now, information or data is easily saved, easily duplicated, and easily transmitted. This is very different from the Daniel Ellsberg having to copy every single page of the Pentagon Papers on a photocopy and then fly. Did you see the movie The Post depicted him on an airplane, with the documents taking up a seat next to him on the airplane? So it's very different now, right? You can get a flash drive in a second, or you can transmit them over the internet. We also have encryption technology that makes it hard to track the transmission of the information, and also makes it easier for people to share information anonymously. So that's another reason for the uptick. And perhaps it's the seriousness of the threats. I do think we've always had some pretty big possible threats to national security, but having had attacks on our own soil on 9/11, that may also have caused a grave concern that we need to protect our national security secrets. And finally, this does relate to technology, because technology has allowed the rise of non-traditional publishers like Julian Assange. So it's not just the Washington Post and New York Times of the world, which, I know the government hasn't always approved of their decisions to publish, but by and large, we have regarded them as responsible. They at least think before they publish. They engage in a dialogue often with the government before publishing. But when you have non-U.S. citizens with access to the information who do not talk to the government and do not engage in any sort of editorial control and engage in mass dumping of information, this is a whole other threat. And so that also is causing, I think, anxiety about the ability to control information, and leads to this desire to crack down on the leakers. Okay, so one of the big things we have to confront here is, how do we balance the undisputable need for secrecy when it comes to national security, but also the need for being able to hold public officials accountable and to have a meaningful ability for citizens to exercise their oversight on the people they have elected to represent them. And so on the one hand, we do have, everyone agrees, there are some national security secrets that must be protected. Troop movements, perhaps. The identities of intelligence sources are often cited. Maybe the codes for encryption, that sort of thing. And that's a very narrow slice. But, there are no doubt many secrets. It went down. We had tried to lower it.
I did that on purpose.
Do you want to see how I roll with it? Okay, so I'm rolling. Okay, so we have this balance, but at the same time, we all have to recognize that the executive branch does have every incentive to keep its activities secret, and we have had plenty of scandals come to light through leaks to reveal to tell us about government wrongdoing. And so the question is, how do we achieve this balance? Now, to date, the way we've achieved this balance is relying on the political branches to engage in check and balancing, and I'll talk about that in a minute. But we've also relied on this, unofficially sanctioned role of the leaker and the role of the press to publish those leaks. And we've had a lot of uncertainty because leakers weren't being prosecuted, and the press hasn't been prosecuted. It's a gray zone, to use the last talk, a gray zone of what the First Amendment tolerates and doesn't tolerate. But we are quickly now, with the Assange prosecution, moving forward to where we might see courts resolving these issues, and it's really unclear how the court will. So before I get to the Assange prosecution, I want to make sure we all appreciate that the government overclassifies. This is not a partisan issue. It is, everyone agrees, there is rampant overclassification. It's not surprising, given that the government has no reason not to classify. There are no incentives not to classify. If anyone's in doubt, it would be better to classify. And so we have this rampant over classification. So I just want to make sure we all know that. We could start trying to engage, trying to fix this problem that I've identified of excessive government secrecy. One way might be to try to fix our classification system. And we've had some efforts that are underway. I will like to highlight the Interagency Security Classification Appeals Panel that's been around for about 10 or 12 years. And here people can ask this panel to review a classification decision and get a decision. These people on the panel are national security experts, and so they don't tend to defer as often as federal judges do in FOIA actions to government claims that secrecy is necessary. There have been a lot of limits to this panel. One is that it just can't timely review every request it gets. It is completely overwhelmed, and people wait years to get decisions. So we would take a lot of money and a lot of resources to create a panel that could actually engage with all of the requests that it receives. So to date, it's been mostly historical documents more than any sort of press inquiries on a day-to-day basis. But it is a bright spot in this area, and I think continuing to think about efforts like that will be very helpful. Okay, so I want to talk about checks and balances, because other things that we have in our system, and you might think of how our Constitution was set up to check the executive and to check executive secrecy. And so to some extent, Congress certainly does check excessive government secrecy. It can engage in all sorts of hearings and oversight, subpoenas. We just saw an impeachment. So there are things that it can do. It oversees appointments. And so there are lots of powers that Congress has to check the executive. But the problem is we have a lot of deficiencies in Congress's ability and sometimes its willingness to check the executive branch. So sometimes the executive branch keeps information from Congress on purpose and doesn't. There's a lot of tension. This is like Con Law 101 here. The tension between what's the proper role of the president and what's the proper role of Congress, and so they fight this battle. And so we see the president, not just President Trump, but presidents generally, not always willing to comply with requests for information or even subpoenas from Congress. When the president does share information with Congress, often it shares with only a select group of people and not all of the congressmen for understandable reasons, again, wanting to control the number of people with access to the information. But sometimes that leads to just continued secrecy where you have just a small handful of people who know something and we don't see any sort of real meaningful public oversight. There have been times when the executive branch has been outright dishonest to Congress. So in March 2013, James Clapper, testifying before Congress, denied that there was NSA surveillance happening. And another thing that's fascinating is people in Congress will tell you sometimes the way they find out what's going on is through the press. So there's this kind of cycle where they will get tipped off through a news report that something's happening, and then that will trigger their oversight. Because if you don't know what's happening, sometimes it's hard to start doing the oversight. And then on the willingness front, of course, when the Congress and the White House are held by the same political party, you often will see a lack of willingness to engage in any true and meaningful checking and oversight of the executive branch. I should also mention the judiciary, which can also play a role and does sometimes, but there are many obstacles to judicial review. For example, standing can be a big problem for litigants who want to get information or to challenge government programs. And in addition, as I alluded to earlier, federal judges frequently are very unwilling to second-guess the executive branch and will cite the lack of expertise and knowledge that they have. And so in some instances, we see the federal courts really deferring and virtually rubber stamping what the executive branch is doing. So there are some real meaningful some real limits on the court's ability to check the executive power. I mean, and many people think the courts are right to defer, right? So I'm not sure that that is going to change anytime soon. So recognizing these deficiencies, Congress passed the Freedom of Information Act in 1966 to much fanfare, and FOIA works sometimes, doesn't work super well in national security cases for the reasons I mentioned already. There is a national security exception in FOIA, and as long as information has been properly classified, it is not subject to a FOIA disclosure. And the courts have been extraordinarily deferential to the classification determinations. Again, frequently citing it is not really our role to, we don't have the expertise to really second guess the government's determination that secrecy is necessary. Okay, so that brings me to other protections. So we do see some protections for whistleblowers. Non-intelligence community whistleblowers have more protections. The intelligence community has fewer protections. And so one thing we might think about doing as we try to strike the right balance is to beef up our protections for national security whistleblowers. Again, by no means is this going to solve the problem, but it could be helpful. We want to make sure we have our inspector generals appointed and in place, and also given the authority to receive complaints and proceed in reporting them to Congress when appropriate. And so we, actually enforcing and regarding this as an important part of the checks and balances of the executive branch might help us deal with legitimizing whistleblowing when we really want it, right? If it's waste, fraud, abuse, illegality, like these are the things we want people to come forward with. It wouldn't protect all leaks, right? In fact, it wouldn't protect most things that people are saying, but it would protect the most important things that we want to know. Okay, so that brings me to protections for the press, and because of the Julian Assange prosecution, I thought it was important to spend a few moments on that. And Julian Assange, as you all know, is the founder of WikiLeaks, and it operates outside of the United States. And so he's now facing prosecution. He's been indicted in the Eastern District of Virginia. And he, in connection with specifically his role in publishing, when I use publishing as a term of art, so disseminating information that Chelsea Manning leaked to him. So it's going back in time. It focuses on 2010 and doesn't focus on Russian hacking or any of the more recent events that Assange has been involved in. So it goes back in history. Now, the Eric Holder and Obama administration specifically considered and decided not to prosecute Assange. Again, 2010 was a while ago, and they decided not to do it, I hear, because they felt like they couldn't do it without posing a threat to the press, because there is no meaningful way, at least not in any sort of jurisprudence I've seen, of distinguishing WikiLeaks from the regular media. And so they decided it posed too much of a threat to the freedom of the press and decided not to go forward with the prosecution. And now that we see it happening, the question is, well, is WikiLeaks, this WikiLeaks Julian Assange prosecution, is it going to be the Pentagon Papers 2.0, the new technologically advanced version? So here I want to share that Julian Assange indictment came down in two phases. There was first a more limited indictment that focused on computer hacking, and that was how it was portrayed. But the DOJ announced it, and the indictment itself focused more on Assange's role in trying to help Manning break into the system using a password, so that it would look like he had authorized use to get into the system. And the common reaction to that by journalists and media lawyers as well was, well, that's not great for the media, but since we don't typically hack into computers or help people hack into computers, it's not a huge threat to journalists generally. But then there was a superseding indictment that specifically added charges under the Espionage Act for publishing national defense information. And so now we clearly have an issue for the press. And so this just, expressly charges Assange for violating the Espionage Act, but it focuses on just his actions in publishing the identities of the human intelligence sources. And so you might remember just a few moments ago I was saying when we agree on what secrets need to be kept, typically the identity of national security intelligence sources falls in that category. For the most part, there will be some rare exceptions, but for the most part, there's a compelling government interest in keeping those identities secret. And I don't think that was an accident. I think DOJ was really trying to bring a prosecution, but in a way that would pose the least threat to mainstream media, which typically does not publish intelligence identities. And so you'll see this reflected in the DOJ press release. They said that they are prosecuting Assange only for this narrow subset of classified documents that names these human intelligence sources. And they also added that DOJ takes seriously the role of journalists in our democracy. It has not and never been the department's policy to target them for their reporting. So we see that DOJ is still embracing. This is consistent with the Obama era of we don't want to go after journalists, but they're saying basically Assange is not a journalist, and what he did is not a traditional activity that we see our journalists in the United States engaging in. And this, Julian Assange is no journalist. So this cues up an obvious question, because you may have heard this press release, like, yeah, he's no journalist. Oh, the problem is we don't have a definition of a journalist. The First Amendment privileges don't revolve on who's a journalist and who's not a journalist. Although we have a press clause as part of the First Amendment, actually the court has never used the press clause. There are no, to date anyway, the Supreme Court has never used the press clause to provide any sort of particular privileges for the press. And I really don't see it likely that it will do so going forward, because technology has made it even harder than it ever has been to identify who the press is. So I really think this is not likely to be a case where the court, if this goes up to the U.S. Supreme Court, where they are able to say, we can prosecute, government can prosecute Julian Assange because he's not a journalist, he's not part of the press. The press will have some sort of undefined privilege, will decide some later date to publish national security information. I just don't see that happening. Okay, there isn't likely to be a statutory way around this. So the Espionage Act, some of you I'm sure know the Espionage Act, and you know that it's not just about spying, even though espionage is typically, that word is about spying. And so it goes way beyond that. It doesn't talk even in terms of classified information because it was passed long before the classification system existed. And the statute itself does not carve out journalists or the press. Now, there are some statutory, looking at the history, legislative history, maybe something there, but I really find that that's going to be a tricky uphill argument. The Pentagon's Papers case, maybe that will provide some insight here. Well, the problem with Pentagon Papers is this is a prior restraint case. It was not a case involving subsequent criminal punishment. And if you add up the votes of many separate opinions in that case, it looks like the court, even back then, left open the possibility of a subsequent criminal prosecution. So again, in Pentagon Papers, for a prior restraint, the court requires immediate and irreparable harm to national security. It is very unclear if that's the standard for subsequent criminal punishment. The court also mentioned that there were separation of powers concerns because there was no statutory authorization for a prior restraint, unlike criminal prosecution clearly there is statutory authorization. And so we really don't know what to make of this. And so with more time, we could talk about, are there meaningful differences between prior restraint and subsequent criminal punishment. If we decided there weren't, then maybe we take the same standard, but we might decide that they're different, and so all bets are off. And so we don't really, the Pentagon Papers case may not really tell us in the end how to deal with the Assange case. So this would leave the court to have to resolve a whole bunch of really difficult questions. So again, Pentagon, what to do with the Pentagon Papers case? Do we defer to the government on its classification decisions and how much? Do we defer to the government on its allegations or assertions of harm or a national security threat? In Pentagon Papers, the government pretty much failed to present any case of real harm. What harms matter? Are we going to see the court grapple with that at all? Does the public's interest in the information matter? Do we balance the harm versus the public's interest? Is there any sort of requirement that the publisher have clean hands and not have been involved with the acquisition of the information? These are all very unresolved questions. Now, it could be in the Assange prosecution, as the court loves to do in many contexts, make a super narrow decision and say this was really harmful information with very little public interest, and we leave for another day how to resolve this, and maybe that would be what we get. I should also mention the government is arguing that Assange is not covered by the First Amendment at all because he's not in the U.S. and his activities were outside of the U.S., and that is not a frivolous argument, so that might be another way to resolve it. There's another case called Bartnicki, and this is where the clean hands thing comes, but this case said that the publishers have a First Amendment right to disseminate wiretapped information. But in that case, the publisher was not at all involved with the acquisition of the information. It just appeared in their mailbox. And the court in Bartnicki said that there was a high public interest in that information, which arguably we would not have. And Bartnicki was not a national security case. So national security is often treated differently. So be on the lookout for that. So the bottom line is neither Pentagon Papers or Bartnicki, which were great First Amendment victories for the press, were not press clause decisions. They were not special cases giving protections to journalists. So I don't think the Assange prosecution is good news for the press, even though it was brought in such a way to try to minimize the threat to journalists. There's a huge potential for very damaging precedent for the press, and we really have to think through going forward, how are we going to balance the need for accountability, but also the very serious need for secrecy. So with that, I don't know if there's time for questions, but...
Yeah, we do. We have some time. 6.5 minutes.
6.5. I love the military precision of this conference.
No. Yes, ma'am. Give our microphone person.
Thank you. Hi, I'm Mimi Kessler. I'm just a citizen who enjoys this conference. I have been interested in the last 24 hours. There's a new whistleblower complaint about the people who greeted the infected people that came back from China, actually from that ship.
Oh God,
and
that was a disaster.
Yeah, and they were not given any instruction as to how to protect themselves or anybody else from this virus, and so one of the things I noticed was that the press is covering the fact that that person is female and has had a career in health and human services, which narrows down who it could be versus the whistleblower that led to the impeachment. The gender of that person was never identified. So I'm interested in how much protection there really is, and exposing people to the coronavirus, is that considered national security?
Okay, so at first I thought that the last part was where you were going with this. So definition of what is national security is not clearly defined. So I could see arguments that it's national security. It's on the fringes, but we're seeing all sorts of public health disasters have obvious national security implications. So I could see the argument, but it is, on the outside. As far as protecting the identity, that is a decision the media tries to make, and when they use an anonymous source, do they say anything about who that source is? And so if you read the paper and you see, because this happens every single day, they're relying on anonymous sources. They, more in the last 10 years or so, because there was such a pushback on using anonymous sources, they started to use as much identifying information as they felt comfortable to lend credibility to the leak or to the source without revealing the source. And so I'm sure they decided that it would lend credibility to the source if they could say that she's female. I don't know why that matters, but the fact that she works for public health, that would give some credibility to the source. And maybe they felt like that would not narrow it down enough. And that on the impeachment whistleblower, my guess is that they felt that saying anything at all in that such very politicized situation was better. But I'm not privy to that situation. That's a great question.
We have a question from the overflow room. I'm not 100% sure. From Andrew Ross, Duke Law LLM. He's saying, should Assange be extradited for current quote-unquote political charges rather than upgrading to terrorism, as political extradition is illegal under the 2003 Act?
Well, I'm not a super big expert on extradition law, but I know a little bit about it, and that is the basis for, one of the bases for Julian Assange's challenge to the extradition is that it is that he engaged in a political conduct, and so that he shouldn't be extradited for that. And so I don't know much about, there must be another, I'm sorry, I don't know that much about extradition law. Beyond that.
Neither do I. Can I ask one question while one of our students thinks of their question? How would you, Mary Rose Papandrea, define journalist if you were queen?
Oh boy. I would take a pretty broad approach, and I know it's not popular, but I would think someone who gathers information with the intent to disseminate it to the public. That covers a lot of people, but that is actually the definition that federal courts have been using for the reporter's privilege. Lower courts, not the Supreme Court. And so this intent to disseminate to the public, that does include a lot of, non-professional journalists. But if the goal is to make a definition and then hinge certain rights and protections on that classification, I get really worried about anything that's more specific, on following journalistic codes of ethics or that sort of thing, because we don't license journalists in this country. And I feel like that's really important. I also will say that a lot of non-traditional journalists have provided us with some really important information. And so to say that they're not worthy of protection, I find really, really uncomfortable with that.
So hypothetically, if somebody had a blog named Lawfire, they'd probably be covered.
You're covered.
One more question. I'm sorry. Oh. Sir.
Sorry.
Hi, ma'am. This is Cade Spivey from Wake Forest Law. I think it was the end of last month. Former Special Operations Chief Eddie Gallagher, released a video where he talked about the testimony that was presented against him by members of his team. And at the very end of that video, he gave there's a picture or a video of each one of them, as well as listing their name and their place of work. And I'm curious how that falls into kind of maybe this narrow hole of whistleblower protection or not, or First Amendment protection or not.
So are they undercover, these people who work?
So their names and positions aren't strictly classified. However, they are given kind of like a special area where we don't just talk about who they are, and they're not usually publicized for lots of good reasons.
Right. So they were the witnesses, yeah. Right. Yeah, I think that would be tricky. I mean, I'm not sure there'd be much they could do about it, but I can see why they'd be really upset about it. I'm sorry, like that's often the answer you have to tell your clients, by the way, law students. Like, that sucks, but there's nothing you can do about it.
And with that, there is.
Thank you, Charlie. That was fun.
You can see why she is such a valuable asset to the legal resources in this area. And I can't thank you.
Absolutely my pleasure. Thank you, Charlie.